Hello, everyone, and welcome to my presentation. This is the fourth in a series of presentations on hotel management agreements. My name is Bob Lana, and I'm an attorney based in Washington, D.C. I have a nationwide practice, much of which is focused on the hotel and lodging industry. Many of my clients are hotel owners and management companies. In the last presentation, I talked about alternative legal relationships between parties to hotel management agreements, the agency relationship, agency coupled with an interest, independent contractor, or with any of those, whether or not it's a personal services contract. In this presentation, I'm going to talk about state law governing these relations or relationships and the potential impact of state laws on the party's choice of governing relationship. And I'll start by talking about choice of law clauses in contracts. If you're an attorney, bear with me because this is going to be something you know, but I hope it's informative to non-attorneys who are watching this. Contracts are interpreted with reference to state law. In most contracts in the United States, little to no federal laws is relevant. Of course, there are exceptions, but in most contracts, and certainly in most hotel management agreements, we're talking about state law. Now, to be sure, the vast majority of law in a contract is the language of the contract itself, which is determined and agreed upon by the parties. However, with any contract, you have to have state law that answers questions about how that language is to be interpreted and applied in different situations. For example, is there a provision that the law simply won't enforce because it's unconscionable? Questions like that are governed by state law. And in any state, you've got two sources of law relevant to contracts. The first and the bulk of it is common law. That's judge-made law, court-made law, and its precedents of court decisions that have built up over centuries. And the second is statutes. These are laws that are made by legislatures, and an important thing to keep in mind is that a statute will usurp any common law to the contrary. What's interesting is the parties to a contract can choose which state's law governs interpretation of the contract. So you might have a hotel management company based in Illinois and a hotel owner based in New York, and they enter into a contract, a hotel management agreement governing a hotel in Texas. They can decide between themselves that contract will be interpreted with reference to the laws of the state of Florida if they want. And for the most part, courts will respect that decision of the parties and uphold that. And in a hotel management agreement, this can be very consequential, as we'll see in this discussion. The most common decision reached by the parties to a hotel management agreement, the one you see most often, is that the law under which the contract is interpreted is the law of the state in which the hotel is located, and there are advantages to this. The business of the hotel is, for the most part, conducted in that state. There may be concerns particular to that state that are resolved by that state's law pertaining to the contract. And unless otherwise agreed by the parties, it's likely to be the state is likely to be the place where any litigation between them related to the contract is conducted. That state's courts or federal court in that state will be where any litigation is venued, again, unless otherwise agreed by the parties, and there are exceptions to that. And there are going to be courts that are in that state that are obviously familiar with that state's laws, as well as attorneys or arbitrators in that state that are familiar with that state's laws. So this is a good approach, generally speaking, and it's a particularly good approach if the parties can't otherwise come to an agreement. And as I said, it's what you see most commonly in hotel management agreements. However, some hotel owners and operators prefer particular states' laws because of case law and statutory law governing their legal relationships that I'm about to discuss. And I'm going to talk about 4 states' laws. And a bit of a history in the development of law on this subject. The first state whose laws I'll discuss is California. The reason why I'm discussing California first is because it's The place where the first case was released in a series of case law relevant to this subject, and it was an early case in the progression. In 1991, the next case wouldn't be issued for a while. The case is Willie versus Embassy Suites, and it was the opinion was issued by the California Court of Appeals. And the facts in that case form a pattern that's going to become familiar in this discussion. In this case, it wasn't just one hotel. It was a group of hotels, each with its own hotel management agreement. The same owner owned them all, and the same management company operated them all. The contracts, I believe, were all governed by California law. I don't think the case says that expressly, but the court certainly applied California case law in its opinion. The hotel management agreements established an agency relationship between the owner and the manager. So the owner was the principal, the manager was the agent, and the contracts all provided for that expressly. And each of the contracts provided that if a party breached the contract, the other could notify the breaching party of the breach, and there was a 60-day cure period. Then for the breaching party then to cure the breach, after which, if the breach was not cured, the non-breaching party could notify the breaching party that the contract was terminated. Well, in this case, the owner didn't like the management company, didn't like the job it was doing, and didn't want to rely on that, and subject itself to all the disputes over whether there was actually a breach and whether the thing was actually cured. So the owner just wanted to be able to terminate them immediately. And it sued for declaratory judgment, asking the court to enter a judgment that it could terminate the contracts at will because of the agency relationship. And as I mentioned in my last presentation, under an agency relationship, one of the fundamentals of that relationship is that presumptively the principal can terminate the agent at will. And so the manager opposed that and said, no, we're entitled to all the remedies that are available under the management contract. They have to go through that procedure, the notice and cure, and there's a dispute resolution procedure in there, and you've got to go through all that. So the management company in this litigation opposed the declaratory judgment that it could simply be terminated. Ultimately, the California Court of Appeals sided with the owner. And applying California law and citing California cases, the court said, quote, it's a cardinal principle of agency law that a principal who, in quotes, employs an agent always retains power to revoke the agency, unquote. It said that this power was absolute and it exists even if the agency is characterized as irrevocable. And I believe in this case, some of the HMAs did say that it was irrevocable. And the court said, no, because of the nature of agency, it is revocable. The court found that the agency was not coupled with an interest because the manager's sole interest in the enterprise was its fee. And that simply wasn't enough. You have to have some more of an interest in the subject of the agency, usually a real estate interest, for an agency to be coupled with an interest and therefore not revocable at the sole and absolute discretion of the principal. It also added, again applying California law, that a hotel management agreement is a personal services contract. And I'll quote again, quote, an injunction cannot be granted to prevent the breach of a contract which cannot be specifically enforced. And it is a fundamental rule that specific performance cannot be decreed to enforce a contract for personal services. The court found that a hotel management agreement is indeed a personal services contract because it requires, quote, the rendition of services which require the exercise of special skill and judgment, unquote. So the owner was allowed to terminate all these hotel management contracts at will. Of course, it had a big fat lawsuit for damages against it. It would have to pay those damages, but it was able, it had the power to push the management company out. So what does this mean? Well, it means if the hotel is in California and you're the hotel owner, it may not be a bad thing to have an agency relationship and have California law governing the contract. So that's California. Let's move to the next state. The next state I want to talk about is New York, and I'm going to talk about two cases in New York. The first is a case commonly referred to as Fairmont versus Turnberry. The technical name of the case you'll see on the slide, but everybody calls it Fairmont versus Turnberry. The case was actually not decided in New York. It was an opinion issued by a federal court in South Florida, but applying New York law. The hotel in this case was in Florida, but the parties under the hotel management contract had agreed that New York law would govern it. So you've got a Florida court here applying New York law and issuing an opinion under New York law. The facts in this case were very similar to those of the Woolley case. Here it was only one hotel management agreement, and it was for a hotel in Florida. As I mentioned, the contract was governed by New York law. It also established an agency relationship with the owner as the principal and the management company as the agent. The contract recited that it was an agency coupled with an interest. And as I mentioned in the last presentation, when you have an agency coupled with an interest, the principal can't terminate it at will. So that's undoubtedly why that language was put in there. Like the one in Woolley, this contract had a procedure for default. If a party defaulted, the non-defaulting party could provide a notice of default, and then there was a cure period, in this case 30 days, during which the defaulting party could cure the default. And if it didn't, then the non-defaulting party could issue a new notice of termination. And here, the owner, again, didn't want to rely on that. They just wanted to get rid of the management company. And there's a dramatic set of facts in this one. The owner actually showed up very early one morning and conducted what in the industry has come to be a midnight raid. They showed up with security guards. One of them was even bearing a firearm, and insisted that the management staff turn over the keys and turn over management of the hotel, which they did. And then the manager then sued for an injunction to reinstate the management company. The court ultimately sided with the owner. The court held that under New York law, a principal has the power to revoke an agency, again, subject to a lawsuit for damages that the management company could file, but the owner had the power to push out the management company. And this was notwithstanding that recitation in the contract that I mentioned, that it was an agency coupled with an interest. The court looked under the hood there and said, no, it really isn't. They said it is, but it really isn't. Because the manager did have some contingent rights. One of them was a right of first refusal to purchase the hotel, but that just wasn't enough. The management company didn't have any real estate interest in the hotel itself, and therefore it was not an agency coupled with an interest. The owner had the right to push the management company out, and it did, and ultimately had to pay some damages, I think quite a few damages in that case, but was able to do it. So again, what's the significance of this? Well, this is one reason why New York law, if you're a hotel owner, is a favorable law to govern, a favorable state's law to govern interpretation of your management agreement, at least on this issue. I want to talk about a second New York case, which is also favorable to the owner, and that's the Eden Rock case. Another case in Florida. Another hotel in Florida. This case was actually in New York. It's a New York State Court, the New York Supreme Court Appellate Branch, which is that state's intermediate court of appeals. Very similar set of facts. The owner and the manager were parties to an HMA for the Eden Rock Hotel, which is in Miami Beach. New York law governed the contract. The owner wanted the manager out. One key distinction in this set of facts, so there was no agency relationship. And the owner just told the manager to leave. The manager sued for specific performance, asking a court, this time a court in New York, to issue an injunction requiring the owner to continue to honor the management agreement and keep the management company in place. On appeal, the appellate branch of the appellate division of the New York Supreme Court sided again with the owner. on grounds not that it was an agency, because as I said, that wasn't established in this contract, but rather this court held that this was a personal services contract. I'll quote the opinion directly, quote, "The parties' detailed management agreement places full discretion with the plaintiffs to manage virtually every aspect of the hotel. Such an agreement, in which a party has discretion to execute tasks that cannot be objectively measured, is a classic example of a personal services contract that may not be enforced by an injunction." So again, as I mentioned in the last presentation, a court will not issue an order requiring specific performance of a personal services contract. So even though this contract, this hotel management agreement, was not one that established an agency relationship, for that reason, because it was a personal services contract, the court would not order the owner to specifically perform under the contract and let the management company back in. So the key point here is that under New York law, a hotel management agreement, if it's like most hotel management agreements, is a personal services contract. One more factor in favor of the owner. The next state I want to discuss is Florida, and I'll be brief here because it's very consistent with the case law that I've discussed from the other states so far. The case here is in a trial court in that state, a state trial court, and as you can see, it's an owner suing Ritz-Carlton. The facts were the same. It was a hotel management agreement between the owner and the management company. This one happened to be governed by Florida law. The owner wanted the manager out. This time, it was the owner that sued, requesting a declaratory judgment that it could terminate the hotel management agreement. And again, the court held that the hotel management agreement could be terminated. Like the last case, the court did so holding that this was a personal services contract. And the court emphasized the degree of control passed on to the manager and the requirement of special skill and judgment for the manager to perform its duties under the contract. Therefore, specific performance was not available. So you can see a pattern here in the last couple of cases. Both of them involved affiliates of Marriott International. Marriott lost both of these cases. It resolved in favor of the owners, and both cases were decided in 2013, one by New York State Court for a hotel in Florida, the other by a Florida State Court for a hotel, which I also believe was in Florida. So what's a management company in Marriott's position to do here? Well, by 2013, when both of the last cases were decided, Marriott had already made a lot of progress addressing this challenge. Marriott is headquartered in Bethesda, Maryland, and beginning in 2004, the Maryland State General Assembly lent some assistance to Marriott and other management companies. That assistance came in a statute in 2004 that's since been amended a couple times. It is Title 23 of the Commercial Law article of the Maryland Code. And you can see there the name of that title, which is Operating Agreements, Hotels and Retirement Communities. I will address only a couple of sections of the title in here. The first of them, I'll just read it. It's section 23-102. The first part of it says, if a conflict exists between the express terms and conditions of an operating agreement and the terms and conditions implied by the law governing the relationship between a principal and an agent, the express terms and conditions of the operating agreement shall govern. So we just saw a case in which the hotel management agreement had recited that it was an agency coupled with an interest. And the court took a hard look at the facts underlying that case and said, no, there's no interest here. It's not enough to be an agency coupled with an interest. It's just a plain agency. And so we're not going to enforce those express terms of the contract. We're going to allow the owner to terminate it. This statute Under this statute, it probably would have gone the other way if the contract were governed by Maryland law. And that applies not only to agencies coupled with an interest, but what if the hotel management agreement says it's an independent contractor relationship? Or what if the hotel management agreement expressly disavows any agency relationship between the parties? Well, regardless of the terms and conditions applied by law, meaning case law, under this statute, which usurps common law, the express provisions of the contract are going to govern. Subsection B of the same section says, and again I'll just read it, that a court may order the remedy of specific performance for anticipatory or actual breach or attempted or actual termination of an operating agreement, notwithstanding the existence of an agency relationship between the parties to the operating agreement. It's interesting that this statute mentions the agency relationship, but not the relationship of parties to a personal services contract. I'll pick up on that in discussion of one last case in this presentation. So it's easy to imagine a scenario in which you've got a hotel management agreement governed by Maryland law, and the owner and the management company don't get along, and the owner wants to kick the management company out and maybe tells the management company to leave. The management company then files an action seeking specific performance, an order by the court ordering the owner to allow the management company to continue operating the hotel. And let's say that this contract is governed, the contract says that there's an agency relationship between the parties. Under this subsection B, specific performance is available if the contract is governed by Maryland law. Here's another section of the same statute. I'll just read it. It says if an operating agreement states that it shall continue for a period of time or until the happening of an event, the operating agreement shall be enforceable between the parties until the expiration of the period of time or happening of the event, unless the operating agreement contains a right of early termination. So again, reinforces a management company's right to continue operating the hotel. And this Maryland statute has existed for over 20 years now. And what has been the consequence of it? Well, it's been tested. I want to talk about the case in which it was tested. Just looking at the citation of this case, there are two interesting things that come to mind. The first is the name of the appellant. It's not Marriott. So we have this statute, a Maryland statute, that undoubtedly was enacted with some encouragement by Marriott, which is headquartered in that state, but is being taken advantage of and used by a direct competitor of Marriott, IHG Hotels and Resorts. IHG is headquartered in London. It has its U.S. headquarters in Atlanta. The hotel in this case was in New York. And yet Maryland law was applied because Maryland law governed the hotel management agreement. So you've got IHG in its hotel management agreement, at least in this case, demanding the application of Maryland law because it's advantageous to the management company. And IHG is not the only Marriott competitor that I'm aware of that has done this. Others have done it as well. The other thing that is interesting about this case is, as I mentioned, the hotel is in New York, and yet the court, as we'll see in a second, did uphold the application of Maryland law to the hotel. And the facts of this case were very similar to those of the cases we've discussed in the past. As I mentioned, the hotel was in New York. The management agreement was governed by Maryland law. The owner wanted the management company out. The management company brought an action for specific performance of the hotel management company to stay in and petitioned for a temporary restraining order and preliminary injunction that would prevent the owner from kicking the management company out. The owner then moved to dismiss that action, and the owner argued that a personal services contract cannot be specifically enforced. It's interesting, the owner invoked not agency, but the nature of it being a personal services contract, or at least that's the part that was mentioned in the court's opinion. The appellate court held in favor of the manager in this case. In every other case in this discussion, the courts have held in favor of the owner. In this one, the court, a New York court applying Maryland law, held in favor of the management company. It enforced the Maryland statute. The HMA, it noted, had provided that either party could seek specific performance where applicable. And the court said, again, I'll quote, pursuant to Maryland law, plaintiff made, that is IHG Management, made a prima facie showing that it may be entitled to specific performance of the HMA, unquote. One thing that's interesting about this case is that the court seems to conflate the personal services nature of this contract with agency. All that common law that I discussed both in my last presentation and in this presentation holds that specific performance is not available to enforce a personal service contract. The Maryland statute, as I mentioned in an earlier slide, doesn't address personal services contracts. It addresses agency. And yet this court just combined the two. It applied the principle to the agency relationship and said, no, you cannot kick them out. We will specifically perform or require specific performance of this contract. And you've got to put the management company back in or not kick them out in the first place. Let me offer some closing thoughts. What's the significance of all of this? Well, first, the choice of state law can make a difference in a hotel management agreement, and it's not something that should be overlooked. Second, if you're an owner and you have a choice, you've got the bargaining power to demand it, New York's not a bad place to have governing law, at least not on this issue. Third, if you're a management company and you have the bargaining power to demand it, at least on this issue, Maryland is your state. And as I mentioned, there are some management companies that insist on it, regardless of the location of the hotel. Fourth, if it's a stalemate and neither party has the bargaining power to demand the favorable law on this point, often the law of the state where the hotel is located, well, that's usually the law that governs in a hotel management agreement. And there are many good reasons for that. Finally, my last point number 5, is that in all circumstances, regardless of which governing law you select, be careful of the contract language and work with your attorney so that that language is favorable to you, whether you're owner or management company. With the law that you've selected, the governing state law, make sure that that language adequately addresses as favorably as possible to you how the relationship is defined. That should be stated clearly. If it's an agency, is that agency coupled with an interest? And if you say that, is that backed up by reality? Is there a real estate interest? And then another point is, does the contract expressly provide consent to either party seeking specific performance in an appropriate circumstance? Make sure all of these points are addressed. That's it for today. Here's some information about me, and I look forward to our next presentation.